Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We could have the roll call, please.
Charles Stadelman. Here. Bill Flynn.
Here.
Scott Liebetor.
Here.
Susan LaRusso.
Here.
Felicia Hollerman.
Here.
Preet Singh.
Here.
David Moore. Here. Wanda Simmons.
Here.
Grace Reed.
Here.
Richard Gilmore.
Here.
Vicki Drumheller.
Here.
Tim Borden. Nick Shaskowski. Sharon Herman.
Here.
And Jeannie Hill.
Here.
Thank you.
Okay, so we'll get started with the approval of the minutes. I think there were a few items. Grace, would you like to?
Yeah, I'll start, but I have a question first. I know that the minutes are not verbatim. That means nobody would be able to do that. But anytime a motion is made and seconded and voted on, shouldn't it be in the minutes?
Yes.
Okay. The very first one that was done was a motion to table 2.02 to tonight, and it's not in the meetings, in the minutes. Boy, I'm really having a difficult time. The second one was when we were discussing salaries. Mr. Gilmore made the motion for $1,500 and $1,200. It was seconded by Mr. Liebetor, and then it was knocked down, but that one's not in the minutes.
Just to clarify, these minutes are not from our last meeting, from the meeting before.
From the meeting before.
So the stuff you're talking about was
Then-
the last meeting, which you'll get probably at the next meeting.
Okay, good.
We're
Then I'm done.
So if we look.
And my packet is at home.
So if you've reviewed the minutes from the previous meeting, if I could have from February 2, if there's no changes, can I have a motion?
I'll motion approval.
Okay, a motion by Grace for approval, second? I'll second. Nick, second. All those in favor?
Aye.
All right, we put that to bed. So we have,
Just, we were approving not last month, not the last meeting, but
that's correct.
the one before.
These
Okay.
were February 2.
Aye.
It's very confusing, isn't it? So our next item is the unfinished business, where we're going to go back to Article 2 about eligibility on city council. We'll ask our attorney to
Yes,
discuss this.
so you all have a copy of what I've done so far. We've got more to talk about, but this covers at least a couple of the topics we've already talked about and decided. And again, this is a draft. This is what I put together, but this language, the language that eventually goes to council for approval, is your language. So no pride in authorship here. If you don't like it or you want adjustments, that's what we're here to discuss. But what I did, if you look at this, the first one is just a kind of a grammatical thing to say, because it did say that you actually continually resided, which was an awkward sentence. So want to make sure that it was clear that from the time you filed, it went back to capture that period of time. So that has been continually. And then I changed the word resided to domiciled. So reason for that, because in legal definitions, residency is an intention. Like I said, you could be living in New York, but say that you're a resident here, which a lot of people do for homestead and things like that. Domiciled actually means physical presence. So I changed that the person has been continually domiciled in the city for a period of 2 years. That's what I believe we talked about, 2 years instead of 1. Then I went ahead, just because definitions are definitions, but you have to look them up, and I'm sure even though we could find certain resources that define it one way, others might define it others, so I went ahead and put that definition in there. Domicile requires residing within city limits And then I put 270 days. You guys talked about making it more than just like, because basically, if we say nothing else, it would be like 50% plus a day. You know, it would be considered more than less. This is one of the areas we're getting into that we'd be kind of breaking new ground. I've looked all over the state. I haven't seen anybody that defines it at all. Some that do define it say more than half the time and things like that. So we're doing a little bit more. This committee, I don't think you honed in on an exact number. I put 270 days, which basically is 3/4 of the year, just because I don't think we can put 365 days because somebody will raise an issue of, hey, you were on a cruise for a week and that didn't count, or you went to visit your kids in South Carolina for, you know, a few weeks and you weren't here. So we have to have some, you know, acknowledgement that somebody doesn't have to be here 365 days. The question is, this is going to be a test case, you know, if it's ever challenged, no matter what we put. So that's up to you. I put 270 because I think that that's a good compromise. But again, this is your proposal, not mine. So if there's any discussion there as to whether that would be good. And then in the last sentence, I changed that residency to domicile again. And then below that, I took out all the cross-outs and just put it clean just to make it easier for you to read. So that is that part of it. And I can kick it back to you if you want to do some discussion on that, and then we can talk about the other stuff.
Let's have some discussion on this with the eligibility piece so that we can possibly make a decision and put that to bed and move on. So who'd like to have some conversation? Who'd like to start the conversation?
Well, me personally, I like the 270 number. I do. Because you figure 365 days in a year, that's 3 months that you have time to go away for a month. Because I know friends of mine that, you know, they go up and take care of their grandkids or whatnot, you know, for a month or so at a time. So, yeah, 270 I think is a good number.
Anybody else?
I agree.
Does everyone like the move to domicile?
Absolutely.
You guys making it too easy.
I like the explanation of the domicile. I was looking at, well, what's the difference between reside and domicile?
Yeah.
You explained that quite well.
Is everyone in agreement to move to 2 years from 1 year? Much? 2 7. So if there's no further discussion on this and the language is okay, then this would be time for someone to make a motion.
So moved.
to move this forward.
Okay.
A second.
And make sure you turn your mics on.
Yeah.
Oh, I thought
Actually
mine,
have to
I'm sorry, I
physically
thought
make the
mine was on.
motion, or just the so moved to another?
All right, so we have a motion from Richard to accept the 2.02 eligibility as written by our city attorney. Do I have a second?
Second.
We have a second also. All those in favor?
Aye.
Any opposed?
All right. Yeah.
Oh, okay.
Yeah.
Mike?
Yeah.
Wouldn't this be the spot that we were supposed to be just discussing the other stuff too?
Right, and that's what I meant about this is what I put,
Okay,
and
so
then we
we're
had
gonna
other
piece it
issues to
okay.
talk about.
All right,
so.
that sounds good.
Yeah, we're going to just piece one at a time because they kind of go in different areas and
Well, I think it would probably belong here, and by other, I'm not trying to be cryptic, I think we all know what we're talking about, but the other stuff about convicted or liens or sunshine and things like that, I think that would fall under eligibility as well. But this we had already firmly decided on, so I could write language. The rest I need to hear more from you guys. But I did do some research and can kind of tell you where I'm at on that. So.
Mr. Stokes, is there like a legal term that would broadly encompass that list that was made up?
There is, but you don't like it already. No, it doesn't encompass the list we have, but that's why so many cities use qualified elector, because that encompasses if you're convicted, you lose your voting rights, and then they have to be restored to be an elector again. So that's what people use. what I've heard here is we want more than that. So if we're going to move into more than that, then yeah, I don't know what term we would use. That qualified elector is what other places use. So, but we want to be more specific than that. We ready to go into this?
Yeah.
Oh, good.
If you use something else other than thank you. If you use something else other than the terminology qualified elector, and when the time comes and we have somebody who is petitioning to be an elector, and that particular phrase actually doesn't disqualify him, it just gets not rescinded, but disqualified, and then he doesn't have to qualify for it at all then, would he? Or would he still have to be qualified elector because that's what the state law is?
The state law sets that standard that to hold public office, you have to be capable of voting.
So we
in
don't really want to
elections. So
change that, do we? I mean, we're trying to, but.
Well, and this is where my explanation needs to come in after doing the research on this. And again, we're going to break a little ground here because I personally couldn't find any place that goes more than this. They tend to go more on residency. I mean, that's a common thing. And actually, probably the closest to us I found is actually Fort Pierce has that 2-year residency requirement. So moving that up, I think Naples actually has like a year and a half and things like that. So that residency needle has been moved by other cities. I haven't seen anyone that has gone more of a laundry list like we're talking about doing right now. However, in state statute, in the Florida Elections Code, it's very interesting because they set what a person, the status a person needs to meet to run for state, county, or a multi-county district office. They do not touch on municipalities. The language they use in state statute for municipalities is that the whole elections process is governed by our charter and ordinances, provided it doesn't conflict with the elections code, because they always reserve that right to preempt us on something. But when you look through the Florida Elections Code, which is actually like 7 chapters, it goes from 97 to 106, chapter 97 to chapter 106, there is nothing in there that sets the standard for qualifying for a city council or city commission seat. So basically, and then I even reached out. We have a group listserv among local government attorneys, and after doing all this and being fairly sure that there was nothing else in there, I thought, okay, I'm going to ask my colleagues around the state, and I sent out a message last week, and didn't get any responses. I even said, hey, if you've even heard of a city that has more than just qualified elector and residency, could you point me in that direction? Because I'd already done searches. I'd picked cities that I thought may have had issues that they would have strengthened that, and nobody seems to have touched on this yet. So we will kind of break ground here. I think we're in a good position. Like I told you at our last meeting, part of my job is managing risk, kind of saying, well, sometimes you have to do things without solid guidance, and so we just manage it and say, okay, well, this is defendable or it's not defensible. In this case, because the Elections Code specifically says that elections are governed by our charter and ordinance as long as it doesn't conflict, and there is nothing in there that sets a standard for a city councilman, I think we're okay going down that road. We don't want to be unreasonable, though. So I think if we're cautious as far as what we say, if we want to go down that road of saying somebody who's convicted my suggestion would be moral turpitude's already in there, but maybe we could do convicted. Any felonies kind of a given, and it's already encompassed by qualified elector. But if we are going to go to the misdemeanor realm and moral turpitude is already in there, we could do any misdemeanor involving a breach of public trust. That would be a little bit broader than moral turpitude. And we could include a misdemeanor for sunshine violation. I don't think we could include an infraction, which most sunshine violations would be an infraction. Infractions are considered civil penalties, not criminal penalties. Plus, like we talked about at the last meeting, public officials, even you guys sitting here who are governed by the Sunshine Law, can step into that so easily. And so you don't want to set the bar so incredibly low that net catches, somebody that was just an honest mistake, So you want to catch, if you're going to catch somebody, you want to catch the real wrongdoers, not the inadvertent, oops, I had a conversation in the wrong place at the wrong time type of thing.
So if we want to open the discussion to, we have our list of all of the things up there. So maybe if we could cross off the ones that already would be covered under the qualified elector, which would be the felonies, right? So
Can I ask a question about the qualified elector? Is if we hire someone for the city, we require a background check. If we allow someone to come into a youth organization, for instance, and coach our children, we require a background check. Maybe we could just require a background check to be a qualified elector.
We could find a way possibly to do a background check similar to what we might do with our volunteers or stuff. It's really tricky because it depends on the nature of the background check. I mean, you can do like credit check, you can do, things like that. But if you want criminal information, the criminal justice information in Florida and nationally is very restricted, and you can access it only for certain things. The problem is, and we talked about this a little bit at our last meeting, being an elected official in Florida, or actually most places, is not considered employment. That's one of those tricky things. So while there are entities that will do criminal checks as pre-employment backgrounds, city councilman is not really employment, and even the volunteers you consider employment, even though they're not being paid, but they're volunteering. But by state statute, an elected official is not considered an employee, and so that gets a little bit trickier. So, and so that's why we kind of talked about it's going to kind of be up to an opponent to search out that information. If somebody filed and they have an opponent and they think they, were convicted of something someplace, they're going to have to do the homework and look through public records to see if they can't find something.
This town, they probably would.
So
who wants to start some conversation about this item?
yeah,
Sharon?
are we going to? Yeah, embezzlement, theft, felony, forgery, all those top ones are all felonies, and felonies is already
So that's part of the
excluded.
qualified elector, right?
And then and conspiracy would be a felony as well. Now, below that, you have misappropriation of public funds. That would be that public trust I talked about. So, and it would probably capture some of the other ones, like like probably perjury or things like that, embezzlement. That would be public trust too. But and that's important too, because anyone who's dealt with the justice system knows a lot of times you'll take, and I'm sure you attest to this, you take a slam dunk felony to the state attorney, and what does he do? He files it as a misdemeanor. And so that's sometimes, or it's filed as a felony, but they plead it out and drop it down to a misdemeanor. So some of these that might be public trust, you might want to capture specifically as far as misappropriation of public funds and things like that. So sunshine is the one I think it would fall under that public trust element. So I don't know that we need to say it separately, but if you wanted to draw attention to it, you could say misdemeanor public trust or sunshine violation. And then if, I don't know if you want to discuss that a little bit, and then we'll talk about
Well,
liens.
yeah, let's take the ones at the bottom and talk a little bit more about them, like, do we really want anyone involved in civil litigation against the city to be eligible? Because that's outside of public trust, right? That's definitely wouldn't come there, but I would not like someone sitting on council that is hiring a lawyer against the people he's sitting next to. Is that, I mean, how do you feel about that? How can we?
Might give someone an impetus to run for city council if, you know, I remember, we've had folks run for city council for single issues, like the walls, the canal walls. Okay, and that was the only issue that brought that person to the table, or brought them to the council dais. And I don't know that there was any litigation in you know, before that happened. But I could see where someone that could be so interested in a particular issue that it would bring them to run for a city council before they, you know, the whole thing was litigated. I don't know.
One of my concerns with all of these, and, you know, if we put something in our charter and it conflicts with state law, we can, you know, we have to be attentive to that. If it conflicts with a constitutional right, it's even a bigger problem. And taking grievances to court and filing lawsuits, that's a constitutional right we all hold under both the federal and state constitution, access to courts. So I would be really worried about that.
Okay.
Now, believe me, I'll be the first, and I've worked places where I've had a council member, and it's a nightmare. I mean, you can't, because under the law, even if we have an executive session to talk about settlement, because they're an elected official, they have the right to be there. So suddenly, you don't even bother having executive sessions, because like, well, why am I going to have a closed door session if the opponent's in the room with us? So you don't, and actually there's a city very close to us that just had this issue come up last week, because the attorney tried to call a closed door session in Melbourne Beach, but it's the mayor that's suing the town. And so that was their whole discussion. They had a 45-minute discussion on that one issue. It was like, why are we having an executive session if the plaintiff is going to be in the room with us? You know, so I would love it if we could avoid that, but I don't think I think that would create a bit of a constitutional issue, where they say, you know, you're preventing me from holding office because I'm trying to redress my grievances in court. So that one I would recommend we stay away from, even though we don't necessarily want to.
Conversation about what's up there?
Yeah,
Sharon?
I agree absolutely that could be an issue. Of course, I think one of the things that we really have to be careful of is that we don't come across as targeting. Because if we come across sounding like we are targeting, and I think pretty much everyone in this room understands what I'm talking about, we're going to have another one right under that last line. We're going to have another case up. So I think that's one of the things that we also have to keep in mind.
So who has something up there that they have very strong feelings about that needs to go into the charter? We can talk through it.
Well, I have a question on the paid all taxes. What if somebody falls on hard times? They're probably trying to make the payments, or I don't know. It's
it's a legitimate concern, and that's, you know, when we look at the charter, it's supposed to be this 30,000-foot level of governance, because then we have ordinances that drill down closer and everything else. And so you're right. You want to be careful that whatever sweeping net you're using is not, you know, collecting unintended consequences, and it could.
you know, you very well could lose out on a very good person who might be in a situation that we have written down.
Very true. So if there's nobody that has something that is absolutely on their list that they want to discuss, what that's kind of saying is that qualified elector is where we are, which is what's already there. So that kind of ends the discussion on this piece of eligibility if we don't have more conversation about it.
I think we need to have the sunshine law stuff in there and the misappropriate public funds in there as well. That covers the little piece that might be missing. So that's just my take.
Any other conversation about those two elements?
Or the,
Sharon?
just the breach of public trust. You
So
said
would
that
those
covered,
elements
that
come under the
covered so
breach of
much
public-
of it.
Let's see.
I think breach of public trust is going to encompass most of that, and I think it'll include sunshine as well. But again, like I said, if you want to mention that separately, we certainly could. The other thing that I think that you all need to discuss is something about qualified elector that I haven't shared with you yet, and that is that there was a change in the law a while back, and it was a restoration of voting rights bill that went through. And so restoring your voting rights or restoring your rights as an elector became much easier after you get out of jail, if you've served your entire sentence, which the big dispute got to be is whether restitution was part of that. Because a lot of times somebody, if they rob a liquor store or whatever, they serve this much time, followed by this much probation, and restitution in the amount of $50,000 or something like that. And so the big issue came whether that restitution piece also had to be fulfilled. But setting that aside, because that doesn't impact us, if you do all that, you've served your time and everything, it's a matter of just filing a form with the state saying, I've served all my time, I'm no longer on probation, restitution's been satisfied, I want my voting rights back, and you get them. And so, that is, and I just want to make sure you understand that with qualified elector is that getting your rights restored is not real difficult. So I was playing around with language as whether we wanted to have that conviction in there. We would still have to have something that if the conviction's expunged, then by operation of law, it's gone, it doesn't exist. But there is a difference, and I think I promised you this at the last meeting, there is a difference between restoration of rights and an expungement of a conviction, so.
So I have a question for you. Let's just say somebody did get convicted of theft. How long of a table would it take for them to get their rights back?
It depends on their sentence. Let's say they're sentenced to, a year in jail, and followed by 5 years probation. They're going to have to serve all that time. Now, that year in jail actually only comes out to, 6 to 8 months, something like that. And so it won't be a full year, but that 5 years probation will probably actually be 5 years probation. If there's a restitution, they'd have to do that. So it depends entirely. It might be shorter. I mean, somebody might get 2 months in county jail and no probation after that. So they might be done in 2 months.
So going back to the very beginning then, how would it put the city at risk to put a timetable on the things that we just crossed out? Let's just say somebody's rights did get restored. Why couldn't we put a timetable where if one of these things were done, you can't serve on council for 10 years? I mean, that's going back to that.
I think one thing, we're much better off, in my opinion, we're much better off letting someone else calculate this stuff, because otherwise it's going to end up becoming a function of the city, because somebody's going to come in and say, oh yeah, well I was convicted, but I only served half my time, and then I was released early, and then I was released from probation early, so actually I was all done on this date, not this date, and then it's like, who's gonna factor that in? It's gonna all fall to city manager, by the way. No, but and then the question is, let's say the city clerk, who's, that other thing I gave you talked about. The city clerk's job is not to determine qualifications, just it's a ministerial act to make sure everything's filled out right. So then at that point, if you have a process to determine that this person actually finished their sentence on such and such a date, so 10 years ended such, what if they dispute what we come up with? is there going to be some sort of appeal right? Are they going to get a hearing in front of council? They have to go to circuit court, or whatever. So leaving that determination up to the state of just saying, okay, an order of expungement, that's clear. State does it, the state decides it, governor signs it, and then we know it exists. Or restoration of rights. Again, state decides it, they decide when all those elements are met, and you get a notice saying my rights are, and then that's what we could, and we could say that needs to be attached as part of the filing documents. That if you've had your rights restored, you attach that with your filing documents. But we would be much better off by letting some other party, like the state, determine those things, and us just have the requirement in place, rather than having us determine that stuff.
Well, I guess it's up to the pleasure of the board. I might be the only one that thinks that we should have misappropriation of public funds and sunshine law stuff on there. If I'm the only one that thinks that, then I'll drop it, but I'm a proponent to putting it in our charter and making it very, very clear.
I am too, Tim. I had one other question. What happens to the outside of the state and they come into the state? Can they get their rights restored?
They can go through that process, because if they're living here now, they want to register to vote here, they would have to have that paperwork. Now, they're not going to get Florida to restore their rights. They're going to have to get whatever state they were convicted in, to give them that clearance. And if that state law is different, then they revert back here, and there's a process in place to say, well, yeah, in South Dakota, it says X, Y, and Z, but here, all I need to do is be completely done with my sentence. And then they prove that to the state, and then the state gives them their letter and lets them register. So
I'm in agreement with Tim. I don't know if anybody else is. I'd like to hear from him.
Charles?
Could we get it in a draft review like this for next week?
and that's what I will do.
Vote on it again?
Whenever
just
I
so we
get
can
direction
look at
from you
it?
guys. Yep.
And then, the ones that Mr. Borden is concerned about, and Mr. Flynn, and anybody else, and take a look at it and vote on it like we would.
Richard?
Yeah, I think it's kind of a moot point. And looking at the job of the city clerk, it says very plainly, unless we change the language in the city clerk and her duties, she can't investigate or anything,
I don't even think we can change her language, because this is from the state. So.
Well, what I'm saying is that, number one, the amount of people that have ever been convicted on a sunshine law can be counted on probably one hand. I mean, the chances of being convicted, although there are people on this town that were convicted, but I mean, other than that statewide, I think the attorney will back me up. The chances of getting convicted on the sunshine law is slim to none, because it's tough to really prove it. And the other thing is, it's possible to violate the sunshine law and do it without even knowing.
Sure.
Okay? I mean, you and I talked on the street, and we talked about something came into the conversation about something tonight, and we talked about it this afternoon, that's a sunshine violation. Okay? So, I mean, unless you talk about the weather or something other than what's happening on this board.
You just turned your mic off, Dave.
And what a sunshine law, I'm talking about a sunshine law conviction, not an infraction. An actual
understand.
third-degree misdemeanor
Right.
conviction of the sunshine law.
But I think it harkens back to what Sharon said. That could be looked at like as targeting. Because, again, statewide, there might be 5 people ever convicted on sunshine. Might be 10. But, I mean, this is how many years? So, I mean, it could be looked at as targeting, and then we're back in court again. So,
But I do think that when the attorney talks about a violation of the public trust, that can encompass several things.
yeah.
That might take up the slack of what we're looking to do.
Well, I'd
to
be in
try-
favor of that, because, there could be gross violations of somebody that
Correct.
ran for one office and then he runs for another office, and you don't want him there if he's screwed up somewhere else. So I would go along with that.
I think we need to look at, we're here to protect the city at the end of the day, and, who's on the dais, and if there's things that we can put in place and change and make it a little bit layer of protection, I think we really need to think about it and consider doing so.
Grace, do you have something?
Yeah. I think that I agree with Richard actually about it being, the sunshine being kind of incorporated with everything else. But what was your second one? Had to do with funds?
Yeah.
I can't read that. That's way too far away.
Misappropriation of public funds, and then, we're talking about the moral turpitude thing, and we're talking about public trust. I think there's some things in there that need to be spelled out a little bit more than just that one statement.
Would it be possible to do something about, when we were talking about being free of liens and stuff like that, what about free of court-ordered restitution to the municipality? Are you targeting there? I mean,
Well,
if
remembering that a court-ordered restitution would be part of the penalty for a conviction, and they wouldn't get their rights restored until that was satisfied anyway. So they wouldn't be a qualified elector at that point. So that restitution would need to be paid.
Sharon,
interesting.
Go ahead. Does that only pertain to a felony?
can you put your mic on, please?
Sorry. Does that only pertain to a felony, or does that pertain to a misdemeanor as well? If they haven't paid their court-ordered restitution?
For the qualified elector, yeah, that's felony.
Only felony? Okay.
Here's a question now. Our boards, construction board and our magistrate imposes fines and penalties. Does that fall under that?
No, because those are all civil penalties, so none of that would be criminal in nature.
So what about an individual that is convicted of a misdemeanor and has a court-ordered restitution?
That if we put language in there, like we were talking about, which I know that's still in discussion, but if we put moral turpitude and public trust, and we required the expungement of that, that will not be expunged until everything is satisfied.
Okay.
So putting that in there would cover it. Qualified elector alone won't cover it, because that's only felony.
Any other comments?
Who runs for office with all those things?
Really?
I know. I mean, come on. I'm looking at all this. I'm like, who would do this? We know who.
So is it reasonable for us to take a motion to ask the attorney to come back with some language for discussion next week's meeting on this item?
Mr. Stokes, real quick, what was the two words that you said, what you just said? You said moral turpitude, public trust. What was those two things?
Yeah, the way I've had it lined out is conviction of any felony or a misdemeanor involving moral turpitude or breach of public trust.
That's what I would like to see in our charter, the exact wording what he just said. I don't know how you guys feel.
You make a motion then.
Could it be and/or?
And/or.
You said, see, if somebody might get confused, if you say a misdemeanor of whatever, and public, mistrust of public or whatever, if they get to the second half of public trust and don't see the misdemeanor and we want to associate the misdemeanor with that, don't we? Or do we?
Or either or.
Either or
Yeah,
and/or.
generally in statutory construction, you don't use and/or or either or. The courts just don't like it. There's actually published cases where they like disregard that and count it as and. We don't want it counted as and.
Okay.
Because then it'd have to be moral turpitude and public breach of public trust. We want to leave it as an or, so we're safer with or. But yeah, and there are other things, and this is a good route to go. I think we're safe in this realm, because one of the other rules of statutory construction is if you start doing a list, it excludes everything not on the list. So
True.
we want to keep that broad, especially for the charter. because it is supposed to be that, overview. So we want to be careful about a list. These two phrases are broad phrases. They're not, if we start listing things, we're going to be locked in, so.
I'd like to make a motion to have it as read, as Mr. Stokes just said. If you
And I
need me to read it
second.
verbatim, I can, but
And I second.
Okay, we have a motion and a second for the attorney to come back next week with the language that he discussed for the eligibility. Any further discussion? All those in favor?
Aye.
Any opposed?
Nay.
Okay, yeah, okay, so that motion
Okay.
passes, so you got a job for next week.
No problem.
Can we get a copy of whatever it is that's given to a candidate that shows up to become a qualified elector in our election?
The one that exists right now? Mm-hmm. Okay, yeah, I'm sure we can get that. We can get that sent out.
Okay, so let's revisit section 2.05 compensation that we passed last time, and now the attorney has given us some language for this.
Yeah, I mean, this is pretty much right down the road as what you all decided on. The one adjustment I made, and I can put it back if you like it better the way it was, but since the vice mayor and council member makes the same, and since technically all 5 of them are council members, but we are paying the mayor differently, it made sense to have the mayor separate because he's getting a different amount than council member. But putting the vice mayor and council member the same seemed a bit redundant, just added words, so I combined those. But you can see I did mayor at 750, vice mayor and council member at 600, and then I added that last sentence that this monthly amount shall increase by the same percentage cost of living given to general employees of the city each year.
I think it looks great. I don't think we need a motion for that.
No, it's because we actually he's just showing us what we had already approved last time. Thank you so much.
Can I make a motion to approve section 2.05?
We don't need a motion.
We don't need,
No?
we
Oh,
actually
okay,
don't
sorry.
need a
This,
motion
oh,
for
so
that.
this is already done. We're done with these.
Well, it was approved, well, no, that 750 and 600 was approved at the last meeting, I just did the language, so.
Okay.
Yeah.
But, yeah.
Yeah, so we don't need a motion
And
for
we'll-
All right,
205.
I rescind
And
that
just,
then.
as clarification, when we get done with all these sections, it's all coming back to you as a package, and you're going to have to approve them all again anyway before they go to council. So, bless you.
Okay, we're going to move on to new business, which is the beginning discussion of Article 3, which talks about the administration of the city and the legal departments. And the first one is Section 3.01, which designates this part of the charter is related to the city manager, the clerk, and the city attorney as charter officers. The appointment of charter officers is by city council. Anyone have any comments or problems with that? 3.03, the removal of charter officers. So the charter officers, if you've read this, Section A talks about removed for cause or without cause, based on the terms of the employment contract by a majority vote of the entire city council. Any discussion about that language? Okay, B, the section is about how to remove a council officer, the process that has to happen with the council presenting charges, and they have to have at least 3 council members support that charge. And with reasonable basis, if you've read all this, it's about the suspension and the process. Does anyone have any questions or comments about that section of the charter? Sharon?
I had one question, and maybe it's covered in their HR package, but it doesn't specify if they are suspended, whether it's with or without pay. Would that be an HR issue?
I think that because it's not stated, it really would be up to council to deal with at the time. Because remember, council is going to have to make this decision because they're charter officers. Generally speaking, the way Florida law is, it's generally going to be with pay, which really rubs the public the wrong way. Every time you see an article about it, you see comments on it, it always rubs people the wrong way. But it's because of the way the U.S. Constitution is written and the way it's been interpreted. Public employment is seen as a property right. And so if you're going to take away that property right, you have to give due process and everything. And this is all, and that's in our charter as far as the hearing and everything, but this is all putting somebody suspended until they get that hearing. So it's kind of one of those things. You'd have to have a hearing to suspend them without pay pending the hearing. And it kind of is, kind of circular. So that's why, generally speaking, you see it when it's public employees, you see them suspended with pay until they can get their due process to satisfy that property right issue.
I kind of like that this language doesn't have a lot of specificity to it, because really, if a charter officer is going to be suspended by our council, it's not going to be 3 months till there's a hearing. I mean, this is going to be an issue, and it's going to be widespread because you're going to have half the council, a majority of the council agree with it. And I think due process, they deserve to get paid, for whatever that time is. Anybody have other comments about that?
I assume that would be covered under an employment agreement with that individual or contract, right?
Yes, yeah, and that's the other thing is that, these individuals do have an independent contract, which will, and then to also tell you the reality of it is most charter officers are professional in their field, and a lot of times when charter officers are terminated, it's politically motivated, not necessarily performance-based, because council's going a different direction and they want somebody new. It happens to everyone. Most people in a position like Brian or myself or whatever would know that you don't want that hearing. Why do you want that hearing? Why do you, because the end result, since they can terminate you with or without cause, you're not going to win a hearing, so you might as well just go. And that's what's going to happen 99% of the time is a charter officer, once they find out that they don't have supportive counsel, they're just going to go. That's going to be the way it generally happens.
Okay, so everyone's okay with that. So the next is section 3.04, which is the city manager's role, powers, and duties. It just is pretty general about he's a chief administrative officer and their role in appointing and suspending employees within the law. That's B. C, does anyone have any issues? Did you read? I'm sure you all read this. Anyone want to discuss any of the role of the city manager?
Well, I have a question for Brian. Is there anything you wish they allowed you to do, or wish they took away, or wish they took away?
Be very,
from you
very
doing?
careful.
I was going to say, I don't think he wants to add much.
Thank you for asking. A private helicopter, not.
So is everyone okay of section 3.04A through G? No questions, okay. So section 3.05 is the city clerk role. And that talks about the notice for meetings, keeping the journal, which is the minutes, and other duties as assigned. You know that the city clerk has a lot of other duties assigned in this one paragraph.
It's all one sentence, too.
Yeah, okay, so we get to Division 2, which is the police department, and that's section 3.06, and that really is just one paragraph outlining that the chief of police will be certified and reports to the city manager. Any questions about police? Okay.
It's also designed very much and very intentionally to maintain our own police department. So there couldn't even be a discussion of contracting with the sheriff's office unless the voters change this.
Change the charter.
Because it's preserved in the charter, and it's there intentionally to preserve that.
Charles?
Police chief?
Police chief
Does
is
it-
a city manager appointed.
City manager does? Does it have to specify who hires and dismisses the police chief?
No, that falls back under the duties of the city manager as far as his responsibility to hire the department heads, because police department at the end of the day is just
Over here, city
another-
manager. Okay, I got you.
Yeah.
Any other questions on that? Okay, when we go to Division 3 Legal, Section 3.09, City Attorney. And that gives the A, B, and C, they serve at the city council retains. City attorney receives compensation. They all have their own contracts and describes their role. Does anyone have any questions for that? Okay.
I want to know why I came after the police department, is what I want to know. Just saying.
I don't know.
Yeah, really.
I guess they wanted enforcement.
Because you have to be watched.
You're a charter officer. You should be.
All right, so we've made it through Section 3, and we can start on Article 4, which is about elections. And 4.01 is adoption of state election laws. And that just looks like legalese for, we have to obey what the state says, right?
Right, and that's in state statute already, so we wouldn't have much to say about it anyway, but it's there, and it's not worth using a referendum question to take it out, because it's redundant anyway. It doesn't hurt being there, so.
Section 4.02 is filing of candidates' oath and the fee. There might be some discussion here since we've had all kinds of elections. Anyone have any comments on these A and B here?
I do.
Okay. And it has the dates, and I think that B is really more about getting stuff to the county and kind of the process of.
I think Sharon has something to say.
What, Grace?
I think Sharon has something to say.
Okay,
She
Sharon.
went, I do.
Well, I was reading this other paper that I think you provided, and, we were having some discussion back when we were working on the other eligibility thing about what we can put in for what they fill out on the questionnaire and that for eligibility. And I think when you've got the printed copy of the oath or affirmation, but when I read the paper that you provided, because we had talked about, somebody could publicly challenge somebody, they get their application for eligibility for council, and Jeannie fills out a paper, and I say, wait a minute, her hair's really blonde, okay? And she didn't put blonde on the paper, okay? According to this, it sounds like you can't, you could publicize that, but you can't, it has to be a judicial challenge?
Yeah, and I think we talked about this at a prior meeting, is that the clerk and the supervisor of elections, neither one of them can refuse to accept something because they think there's inaccurate information. It can only be done through a judicial challenge, and it's not going to be done by the clerk or the supervisor of elections. It's going to have to be done by an opponent or a member of the citizen, some citizen out there that says, hey, you put this down there and it's false. But yeah, it would have to be, it would only, and that not only protects the candidates, but it protects the city. I think I mentioned this once before, but Vero Beach went through this just a few years ago, where their clerk didn't let somebody on because they didn't think they met the residency requirement, and the judge disagreed, and it cost Vero Beach a lot of money to have a special election to do a do-over. So that's why we're much better off not taking somebody off the ballot unless a judge tells us that person comes off the ballot.
But my question is could a citizen, like I could say, oh, I challenge what she's saying on this, but all that would be for sake of argument, a Facebook opinion, okay? In order for me to really say, hey, they're not qualified, I would have to file a suit as a citizen. Is
Yes.
that's
Yes.
what I wanted to understand?
Yep.
Okay.
One of the things in reading this charter that becomes quite obvious is how much citizens need to know about what's going on in their community and vet
Yes.
people, because it's up to us, right? Really, it's up to us to vet. And it becomes clearer and clearer as you push through here.
Okay.
Are we done with that conversation?
Section 4.02.
Yeah, I want to ask Kathy a question. And you may not know this. I may need to check it and bring it back. But B concerns me with the 81 days and 96 days. I dealt with this in another city where those days needed to be adjusted because the state has added a lot of added time because of early voting and because of overseas ballots and everything else. They moved back. It was actually, share this with you because we've changed it since then, but when I was in Port St. Lucie, it actually talked about special elections, and if there was vacancy in office, there'd be a special election, that you'd have a 2-week filing period, and then you'd have the election in 30 days. Supervisor of elections down there laughed at us like, yeah, that's not possible. I don't care if it's in your charter, it can't physically be done because state statute requires all these timeframes for mail-in ballots and everything. So I want to check and see if these dates are good, unless you know already.
As far as I know, they
These dates are, 81 and 96 still work for us? Okay, all right. But yeah, we'll let you know if that's different, but sounds like right now we're okay with those numbers, but we'll let you know.
So section 4.04, special election for other purposes. Does anyone have any comments or improvements or changes in that? Everybody's okay. All right. So we'll go to section 4.08, which is city canvassing board, canvass of election returns. And this, is this for when it's not a county election?
Yes, this would only apply in the very narrow case where we're
special
having an
election
election and
just
it's
for the
just
city?
us. Yeah, because if it's a joint election and you're, have state house and president, vice president, or county commissioners, whatever, then that's the county canvassing board. So this would only be if it was a special election just for us.
Has that ever happened
Yes.
Yes.
here for us?
Yeah, I was
We
on
had
a
a s-
canvassing board when I was city attorney last time.
Oh,
Jim, we also do have we do sit on a canvassing board every other election. So in it's the odd years, right? Yeah, 'cause last year.
That's true, because then maybe that's what it was.
Yeah, we do
Because,
sit on the board.
because we have the 2-year
The
terms.
2-year terms.
We have an election off-cycle with the county and state, so.
Yeah, so every odd year, we have a canvassing board.
so this basically is just process for that, what's considered a special election.
Right.
For us. Okay. Anyone have any comments about that? Section 4.09 is about ballots. And that's basically just says they have to conform to Florida law. 4.12, election procedures in a tie vote. Have any concerns about that? Section 4.14, interim government. So this is about when there's not a majority of city council serving.
What are the odds?
I don't know. But I guess we have it covered, right? It's something, no conversation there. And so we're not going any farther than that, because that's where we said we were going to get today. We'll do Article 5 next time. That's good. We got through a lot of work today. Anything from the staff?
Nothing.
Any of the committee have anything before we go? I do want to tell you that we have a meeting next Monday, March 9th, but the city clerk has let me know that the following meeting that's scheduled for March 16th, there was a conflict, and we have to move it to March 17th. So that'll be Tuesday. March 17th instead of Monday, March 16th. But we still have March 9th. We have next Monday going on. Okay? All right, we are adjourned.
Madam Chair, real quick.
Oh, excuse me, I'm sorry.
I won't be at next week's meeting because I will be out of town and I won't have Zoom accessibility. So,
Okay.
just to let you know.
All right, so if you see something, if you get the email
Yeah,
and there's
yeah, and
something
then
you
I'll-
want, be happy, please send it forward. All right,
Absolutely.
at this point, we're adjourned.
I can go to bed early.